Welcome to the live. We're going into the Supreme Court rulings. And a lot of the problem, well, I don't want to say problem, a lot of the trend that we've been seeing in the past few years is that the power is shifting back to the agencies, away from the people. So one particular example is the consular non-reviewability. The situation was this. A US citizen woman wanted to petition her spouse to come over to the United States. The case got denied at the consulate. If that happened in the United States, we would appeal. We would argue that it was wrong. And if that gets denied, we'll appeal again, right? And you'll keep on appealing to have the courts take a look at it because agencies make mistakes. And the way our American democracy, consulate, foreign affairs is set up is that you give a lot of the power to the different individual officers, and that the consular general doesn't really want to step in and overturn a individual's decision, kind of like the jury system, right? The jury decides. But unlike the jury system, when you appeal a case, when a case gets denied and you appeal it, you could go up in the judicial system. But for immigration purposes at the consulate, when a case gets denied, there's non-reviewability. You can't just file again. You can't just appeal again. Sometimes it's done. As a U.S. citizen, how does that make you feel? Well, a lot of people feel that that's wrong. And so this case went before the Supreme Court, and the Supreme Court now has to decide the ability of a U.S. citizen to petition their spouse or significant other, or a company petitioning an employee. Is that a constitutional right that the courts have the ability to come in, to step in and adjudicate? Matching that with a public policy of having consulate non-reviewability, having consulates completely under the jurisdiction of the president, of the executive branch, of foreign affairs. The judicial system shouldn't step in to review things outside of the country. Those are two constitutional questions. This Supreme Court in June ruled that consular non-reviewability is much more important. An individual as a U.S. citizen or a company trying to bring a foreigner from outside into the country is not a constitutional right. It might be unfair, it might not be efficient, but it is not a right like the Second Amendment. If you want it, Congress has to put it into the Constitution, right? And so the courts does not have the right to review consular decisions. That is moving power away from individuals to the agency. And we've already talked about, we spent the entire live session last week talking about how customs officers have the authority to now deny lawful permanent residents entry back into the United States. If they leave the country, they come back in, well, maybe I'm only going to parole you in. I'm going to cancel your green card. I'm going to hold your green card, right? And so a lot of that right now shifts again to the customs. Now, customs can say you don't have the right to even apply for asylum, even if you're showing up in front of me. Now you need to use this app. Now you need to use this queue. Now you need to wait a lot longer. Yeah, if it expires, well, sorry, you didn't apply for asylum on time, right? And so now moving power away from to the agency. You might say, well, I remember there was a Supreme Court rule that allowed courts to have a lot more jurisdiction over agencies. Yes, that was 2 years ago in 2024. It overturned the Chevron defense, which was a huge deal and is a huge deal. Agencies are making all sorts of policies, and in the past, based on the Chevron defense, courts have deferred to the agency's logic and their ruling. But now, based on the 2024 ruling, courts can go back and look at their internal policies. Hey, your policy, does that make sense? Is that the correct interpretation of what Congress intended? However, after 2024, in 2025 and 2026, we see a new wave of decision semi-undercutting that policy. Why and how? Well, yes, courts are not going to longer defer to agencies' interpretation of what Congress meant and how they wrote it. However, courts will still defer to the agency's fact findings. What does that mean? Well, when you come in through the border, when you come in through, airport, whatever the officer have typed in, you can't see it, but they see it, they typed it in. That becomes fact. Whatever you submitted, whatever the officer adjudicated, interviewed, and wrote in their notes, those are facts. Let's say you're trying to overturn a case years later, and you say that was an incorrect fact. I want the court to come back and re-adjudicate this case. I didn't say that, or I said this, but they didn't record it, and they now use the faulty logic to deny my case. The courts are saying we're not gonna step in and review the fact finding if it's too long. So that the takeaway from that is when you prepare your case, you really now have to document it because the courts can't save you later on, right? And so all of these Supreme Court decisions, moving power away from individuals and the courts to the agencies, to the people administering. Is that a good thing? Is that a bad thing? That is not the purpose of this live. I'm just reporting what's happening on the Supreme Court rules in various different situations. And now that is what we're seeing, and the trend is going to continue. When the power is moved away from individuals to the agencies, when courts are no longer adjudicating cases and overseeing fact patterns and fact finding, it's up to the different officers. We need better officers. We need better trained officers. We need better paid officers. We need fair officers. We need just officers. And that's one reason why, me joining the American Bar Association's nonprofits, going down, talking with different officers, me going down to AILA, doing these tours, talking to the officers, us being as a private bar, we provide our services to different officers in different agencies. We do these AILA conferences and we invite the officers and we provide proposals to the officers, right? We don't just advise Congress with the policies that we recommend them implementing in the new tax and immigration reform, but we also provide these suggestions to local customs officers, to local USCIS officers on how they should adjudicate cases as well. And the impact is it will have. Because a lot of these officers, they don't have a lot of immigration training, especially the customs officers, right? Because if you think about it, what are they? They're trained on wildlife security, right? You don't want to be bringing in, leather and feathers into the United States. That might actually harm the wildlife here. You don't want to be bringing in fruits and vegetables and seeds. You don't want to bring in IP. There's a lot of IP theft, right? And so how do you safeguard everything, right? And they also have to know all the names of all the different gangs and terrorists, let alone all of immigration law, right? They don't have the resources and training. So as a private bar, we provide our services and help so that they can have better guidance, they have better policy to adjudicate certain things, and so that they could become better and just officers. So when they review a situation based on their vast discretion that the Supreme Court now have granted them, that they would make the right choice. That is why we do what we do, and that is the trend of this country. And if you are looking for a job, and you are a good and fair and smart individual, I highly recommend working for the government because the government needs more smart, capable, and they're always hiring, right? Every time I go down, they're doing more trainings, they're doing more hirings. The background check is extremely long, but we do need better officers, right? And again, they're burnt out, they're tired, their vests are heavy, their burden is heavy, they have a lot more responsibility without increasing in pay, but they are doing their best, and we are there to support them. And if you guys are applying to those jobs, I trust you guys are good and you guys are going to get good training. So that's how we make America better together. I'll take some questions.
Any tips on how to maximize the chance of an F1 interview approval?
How to maximize it? Go to the basics, right? Having applied to a good school, why do you want to go to that school? What professors do you know? What do you want to study? What are you good at? What are your grades beforehand? Why can't you study in another country? Why can't you study in your own home country? What is this big move from your whole family to go to the US? Why? This is a big expense. This is a big investment. Why? Right? And where are you going to live? How are you going to support yourself? What clubs are you going to join? Be able to articulate that in English and be able to articulate that well, right? Watch some US movies beforehand to get the accent down, to get the attitude down, right? If you went to international school, do you have letter recs from different teachers supporting you to go on this, embarking on this huge journey? these are the things that we go over with all of our international students, right? Hopefully that helps.
My wife is from the Philippines, has been here legally for 2 years. It's now time to renew her green card. She was approved, we did biometrics. Now it's been over a month and her green card's about to expire. What should we do to get that green card sent in the mail?
I think you're trying to apply for the 751, and that is going to take maybe 3 to 4 years to adjudicate. But don't worry, because once you apply for it, you'll get a receipt that says your conditional green card is extended for that long. And so, with that extension paper, with that conditional green card, it's as if nothing changed. So, continue to live and work, and you're fine. And hopefully, 3 years down the line, you get that interview, you ace that interview, then you get that new 10-year green card.
Can she travel outside the country or even domestically?
Domestically, so I can't even say domestically anymore. You know why? Okay, in the past, yes, but now customs is doing these new enforcements where even if you're flying domestically, they can still stop you. Now, you have a green card. If everything is fine, you're fine. But let's say there's a conviction on your record, right? God forbid, there's a pending charge. The current Supreme Court just ruled, 2 weeks ago, you leave the country, you come back in, customs might not let you in as a green card holder. So it's definitely not safe traveling outside and coming back in if you have problems in your case that arise even after you got your green card. Domestically, 99% should be fine, but we've seen this at Puerto Rico, we've seen this in various parts of the country, in Guam, where entering the territory was fine. Leaving was the problem, where they confiscated people's papers. Again, if you don't have any problems, should be fine. But if you do have criminal charges, if things are pending, you get a tax lien, there's certain issues that customs could be alerted of, your green card could be at stake.
Good afternoon from beautiful St. Kitts.
Huh?
If I go to the U.S. to study economics, can I work there and live there for 2 to 4 years?
Look into the OPT program. In the past, if you are on a STEM major after you graduate, you can get 1 year of OPT, meaning you can stay and work for 1 year, and then you can extend it 2 more years, so 3 years total, without having to apply for additional visas. That is the case up to now, but that is the chopping block. Current USCIS really doesn't like that. And so will the 3 years become 1 year? Will the 3 years become much more strict, so you have to apply to each different job and location? These are all high possibilities. But if you're asking just right now, you come here for schooling after 4 years, will you be able to authorize to work? The question is most likely yes, you will be able to, but how you are able to is going to drastically change. How difficult is it to apply for this occupational practical training, right? So, and then that's already the easy way to stay and work. If you want to stay and work much longer, you have to look into the H-1B, you have to look into the L-1 and the E-2 and all the other different categories.
Is Birthright citizenship back?
It's never gone away. It was the same, and the Trump administration used an executive order to try to cancel it, and the Supreme Court ruling said no, that can't be done. Congress has specifically given that right, and so if Congress wants to change it, they will probably change it. I don't foresee it changing anytime soon, but this definitely lays the precedent for USCIS, the immigration agency, to really do a lot to curtail the rights and privileges of citizens, right? So USCIS have a lot of power to change what citizens can do, how they go about doing things, right? What forms they have to fill out, how much it costs, etc. So they can make a lot of the rights and privileges of citizens much, more limited, including denaturalizing people. But people who are just born in the U.S., they still get that citizenship.
Is it fine to travel with travel documents with green card pending from asylum?
We're not asylum attorneys, so we don't have a lot of stats and facts about that. Generally, from what I've heard from other asylum attorneys, if it's a short trip to Canada, Mexico, if it's a short trip to not the country that you're fleeing from, generally it's okay. But if you're going back to your home country, it is generally extremely frowned upon.
I got civil penalty fine, 1.8 million, What do I do now? I have my U visa pending with deferred action.
We don't do U visas, and I don't know if that will significantly impact your U visa case. From my understanding, U visas is extremely lenient as in the sense of waiving almost everything that other things can't even waive. So maybe you have a civil fine, but maybe U visa can still waive it. You would definitely want to talk to an immigration law specialist that works on U visas.
DWI, before I got my green card, told the officer at the 45 interview about this, but am I at risk entering the US?
Nowadays, more and more so because of the Supreme Court ruling, the officer might say you're seeking admission. You know, that is a crime of moral turpitude. And we've had a case earlier, was it this year or last year? No, I think it was last year, where they committed a crime, they got the green card, they traveled for 20 plus years, and then just last year, coming back in, taken, right? Green card taken to detention center, and deported. Family, U.S. citizen. He almost became a U.S. citizen last year, but he missed his interview. You know, so it's just a one step he could have gone, but he just didn't. So, but customs made that discretionary call. Now, is your situation like his? His was a drug offense, much more serious. Is yours okay? It's going to be up to the officer. My recommendation is have your court disposition prepared, have proof that you've been in the U.S. and a green card holder for over 5 years, and that you are not seeking admission, right? Try to make that argument, right? And that you deserve to be able to come into the country as a green card holder.
And what are some ways to argue I'm not seeking admission, I belong here?
So if your trip is under 180 days, that will help you, because if it's over 180 days, they have additional reason to say you're seeking admission. So that's one. The second thing is, if your charge is not a criminal offense, if it's a civil offense, you could try to make that argument. If the case has been completely dropped, it's not even on your record, if it's expunged, they don't buy that argument, but you can still try to argue that. These are a few things. I mean, obviously, we need to know more about your case to see what else you can try to argue. You could always use just general equity arguments. You know, I'm a doctor, I'm doing this thing, you know, it's really important for the country, I really need to work, I need to keep my green card, etc.
And yeah, does good moral character arguments, does that factor in here?
Loosely, right? I mean, if the CBP officer is talking about good moral character, I mean, you're way in the deep end, right? Because usually that line of questioning, and when your good moral character comes up and letter recs, that is at the trying to apply for green card phase. So if that comes up, basically the officer has already considered you are seeking admission, and they are really deciding whether to give you your green card back. So if it comes up, you're really already in deep waters. But do your best to argue, right?
And if the officer does think you're seeking admission, like, what does that actually mean?
That just means that they are considering whether or not to confiscate the green card and parole you in, similar to asylum seekers or similar to people who are crossing the border illegally on humanitarian parole. But basically, you become like almost like a tourist again. You lose all the rights and privileges of green card if you're just paroled in, where you have to renew the parole stamp every couple months. It's extremely annoying. So they're deciding to do that or to let you in as a green card holder. That is what seeking admission is.
It's been 16 months of waiting on my wife's spouse visa to get approved. Is that normal? What should I do?
Certainly, we see if it's a visa category, I-130 for the visa category, 16 months is somewhat normal, especially if you're just a green card holder. That's even more normal. But as a U.S. citizen, these things are taking a lot longer. Now, if you are in the U.S. and you filed the I-130 and the adjustment status, 16 months is on the slower end, right? We see certainly some within 4 months, 6 months, 8 months. So it depends on where you are.
I'm 3L now, and thank you for sharing your knowledge. It's inspiring. Immigration law is the goal.
Wonderful. My recommendation, keep on doing different clinics in school. Check out different fields of immigration law. Join AILA, American Immigration Lawyer Association, before your student status passes out. I was the AILA liaison for law schools and law students for several years. I pushed to change the AILA bylaw to allow students to get free membership. It used to be pretty expensive, and everything else is already really expensive. I pushed it. We got it passed. It's free for students. You can join, and if you don't join, and once you get your law license, once you graduate, it's going to be over $1,000 to just be a part, of these listservs. So you can still join now. You can still learn a lot now, and you can volunteer at different AILA organizations and conferences, and you can get a lot of insight onto what is the best immigration law for you.
Has USCIS started processing cases again, like 212F, or not? I haven't heard any update from USCIS to anyone. Could be about the 39 country ban.
I don't know. Yeah. I don't know if they're processing those cases again, but they're certainly processing a lot of cases. Yeah.
So yeah, let us know 212F, but is this impacted by the 39 country ban? His wife is from Indonesia, and he's been waiting for 16 months.
Right. So because you're filing the I-130, you're waiting for the embassy, you're waiting consulate, it just takes that long.
Are you AI?
Am I AI? Well, let me see. Will AI be able to do this? Probably not. No. Are they able to get these dimples? Come on, right? AI's not that good yet. No, I am not AI. I'm based here in Los Angeles, California. We've been here for a very long time. I graduated Pepperdine Law School, but thank you for the compliment. I mean, AI usually makes things look really, really good, so thank you. Appreciate it.
Tell us about changing status from F1 visa to seek asylum or green card.
We don't do asylum cases, so it's hard for me to kind of advise on that. General knowledge from what I've learned when I was studying for this specialist exam, you should apply for the asylum within a year of entry. So if you came in as a student and it's within the year and you can file, maybe it's doable, but you definitely want to consult a asylum consultant on that. As far as F1 to other case categories, right? B1, B2, for example, H1B, for example, O1, for example, these are all popular options. B1, B2 is a tourist visa, so maybe you just graduated, you still need time to wrap up your affairs in the U.S., you want to be a tourist, you want to travel, you want to go to Yosemite, submit the 539 application, you want to change your status. If you want to change it to an extraordinary ability status, right? You were pretty famous in college and now you're recruited by a team and they need your services, then you could do the O1. Most often we see people change to H1B, right? So you get selected for the lottery, you file it. Right now we just finished filing all the H1Bs at our firm, and so we're waiting for decisions, right?
Should I wait to adjust my parents on D1 to 45I for over 30 years, or wait?
I think if you have a good case, you should file now. So 245I, the May 21st memo that came out and said you should apply back to your home country doesn't quite apply to your parents because they've been here for so long. It's unreasonable for them to go back. So the memo doesn't affect you guys. If you guys have a good case, build it up, make it better, and file it. It's super important. Now, today's Supreme Court ruling, right, or this past few weeks, is the Supreme Court ruling, does apply in the sense of there's a lot more power going from individual applicants to the agencies. So I'll talk a little bit more about that. But just generally speaking, if you have a good case, you definitely want to prepare well and apply before it gets stricter and stricter and stricter. And that is the trend. It's almost guaranteed that we're going to see new memos come out every single month, making the agency stricter on these cases. So you don't want to just miss that threshold and then now you can't get the green card anymore, right?
Well, yeah, law student is a part of AILA. They love it. Naturalized citizens themselves. They speak 5 languages.
5 languages. Props.
Anything we can do to speed the process along or get the wife who's in Indonesia here while we wait for approval?
Yes, you could look into 2 different types of non-immigrant visas that allow for immigrant intent. So not most visas, if you have immigrant intent, they won't give it to you. So tourist visa, F1 visas, these won't allow her. But the H visa and the L visa and the O visa slightly allow for immigrant intent. So if she qualifies for those, you could quickly apply, potentially get her in, maybe even this year, right? And then you can wait the rest of the time. Now, you've already waited so long, maybe a few more months, she's able to get their immigrant interview. Maybe it's not worth it to spend all that time and effort to apply for a different visa category. If you just want to push this visa category faster, you could try to expedite it with the consulate. Now, you should have a really solid reason, and maybe you can have congressional support, whether you're a senator or congressman, to kind of write in to talk about why you need this humanitarian expedited processing. But you really need to prepare because everyone around the world wants things to be faster. In the sense of immigration is so slow, so you have to have a really good reason.
Okay, for our YouTube audience, I'm hearing some reports that our audio is bad. Is that still the case? Have I fixed it? Can parents petition for their kids with green card
Can parents petition their kids?
if they have green card?
Most of the time, when you are a parent and you got the green card, your kids automatically get the green card with you. There's the NA3 where you could just pass on your green card status to your kids, so that's doable. If you come into the country within 2 years, but if you want to file the I-130, you want to make sure they're a child and not married yet, and so you could check out the family petition to see exactly how long it's going to take.
They just had their interview, I assume for marriage. He didn't ask us about our relationship or documents, only PUB questions and gave us paper.
PUB,
Public?
public charge. So wait, this is a marriage petition?
Mm-hmm. I believe so.
Marriage petition. They didn't ask for joint documents. It was a quick interview and gave them paper that says go back and wait. So that could mean a lot of things. I wouldn't read too much into it. It happened. It's done. Do your best to continue to prepare as if you're going to get a second interview. You could continue to prepare as if you're going to get a request for evidence for a really challenging one, so you can respond to it. But do that on your free time. Do that if you're stressed. But it happened already. It could be a good thing. I've definitely accompanied clients to interviews, and the officer says, I'm going to prove this case already, so I'm just going to ask a few questions. I already did everything. I'm pretty sure it's real, and then the case is done. Sometimes they take all the stuff that we give them, and then they say, okay, you can go home. We'll review it. We'll get back to you. That's totally happened before. So it depends on your background, right? I know some friends who have gone through this process. We represented them. They have security clearances, right? They are themselves an officer. They're already an officer. They've already checked by the federal government, by the government. And so to U.S. immigration, this background check is already, far better than what they do. And so they just kind of glance through it and prove it. So it completely depends. It might not be a bad thing, but if you're stressed and it could be a bad thing, you have a lot of red flags, well, then go back and prepare. And when you get that, request for evidence, then you can respond.
I'm hearing reports that Bro's audio is cooked, not for TikTok, but for YouTube.
Our YouTube one is to go.
OBS said it's fine. Okay, yeah, they did mean public charge. Does the state I apply for adjustment matter? I read that so wrong. Does the state I apply for adjustment of status matter? Border states versus non-border states.
It depends on the officer. Every district office adjudicates things differently. So I could say that as a fact, right? Vegas, California, Colorado, Texas, New York, all different. They have different agencies, they have different standards, they have different discretions. This is a fact. I don't think any immigration attorney or the government will dispute that. They advertise it almost, saying like, hey, different agencies using their own discretion, they know their own demographic. So now to your question, what should you do? Should you apply somewhere else? Should you apply where you are? They also see people shopping for better places. And sometimes people inadvertently shop at the wrong place and it might actually harm you. For example, based on your ethnicity, your background, your work, if you somehow go to a brand new place with less documents and they're not used to interviewing people who are like you, they might cause more scrutiny. You see what I'm saying? So you could move and within 90 days, you could file the adjustment status at a new place. That's totally doable. But if you pick a wrong place, it actually might harm you. I think more often than not, it doesn't make a difference. Unless in very select instances, we definitely have advised clients this is not the best location, that's not the best location, you should probably move. It will just increase your chance of success by 20%, 30%. But those are very selective focused situations, right? Their job allowed for it. It made sense. They had family in a different area. People will understand them better. They could sacrifice a year to give birth. And if things piece together, there's certain places that are better. And so I think that is the nuance that you want to get into. But big picture wise, does that officer understand your situation, right? The people around you, are they getting approved? Do you have a very difficult situation that it's a really challenging denial? For example, let's say you've constantly leave the country and you have a travel issue and you're applying for citizenship. Well, certain offices are much more lenient on that compared to other offices that they see a lot of international travelers, right? So New York, California, Vegas, typically a lot more lenient in that sense compared to some of the red states who don't see a lot of international travelers, right? So hopefully that gives you all the information you need, and probably you're overthinking it. But if you are one of those unique situations, then you can strategize.
Does psychological therapy help with VAWA cases?
All the vendors who are advertising their services to say that, yes, we are psychologists, we can help you write a report, of course they will say it helps. Have we filed a lot of cases without it and got approved? Absolutely. Does which vendor, which psychologist you use, and their background and how long they've given you therapy and how long is their written opinion and how reputable are, do they matter? Yes. So the answer is yes to everything. But what I want to advise is that is just one. Think about it. Maybe 2 points, 5 points out of 100 points, right? There's so many other things that you really want to focus on. That is just part of the cherry on top. Now, sometimes the cherry on top can make a big difference in a sense that it's a cherry pie. It links everything together. Pretty important. But if everything else is really, really strong already, the cherry on top is just a cherry on top. People sometimes don't like cherries. If your case is really, really, really weak, there's a high chance of it getting denied already. Having this might not help that much, right? So put things in perspective. Don't be in a situation where you just feel like, oh, I'm so pressured, I'm so worried, I'm just going to spend money here and there and just get anything I can, right? The advertisements from these vendors that I know very well, of course they're going to say it's important, but have we seen a lot of cases get approved without it? Absolutely. It's not necessary, nor is it sufficient. Think of your case as a whole. Does it make sense for you to have it?
Would you say Vegas is more lenient when it comes to adjustment of status?
I would not say that as a blanket statement. They are definitely strict on certain other areas that other districts don't see very often. And so they are strict in some things and they are a little bit more lenient on other things. I wouldn't say they're, just as a blanket statement, that they're generally more lenient. Now, are there a lot of immigrants there? Yes. And so it is a immigrant powered kind of community, but are there a lot of officers who are anti-immigration? I also see some of that also, right? Compared to, say, many parts of California or New York. So it really depends on your background, what you do for a living, your situation. Does it fit Vegas, right? Do they want more people like you in Vegas? I think that's a better way to kind of think about it.
I will be doing the F1 visa interview soon. What's the rejection rate and any advice?
Rejection rate? It's definitely going up, right? Compared to a few years ago. This used to be something done pre-COVID a lot. I've seen it less important now, but as a good advice, I'll just mention it. At the consulates, we've been told with consulate interviews, they want to see how you coming to the U.S. will make America stronger, safer, more powerful, and wealthier. Explain, right? How does this? And so that's the new trend, all about America. The old trend is all about that education plan. Why are you choosing to go to this school? How does studying this class, this degree, help you to have a better career and make the world a better place? That was the old trend. So if you want to really make your case as strong as possible, merge the two of them. Now, in your application, you really only have maybe a conversation, 3 minutes, 10 minutes at the interview. That's after the basic DS-160 form. That's after double checking your family background, where you're going to be living in the US, the I-20. Just double checking everything else, that probably takes a good 15 minutes already, right? And then after finding out who you are and everything, then becomes the key questions. Why are you going to the US? Why are you studying? What do you want to do with your life? Those are things that they kind of want to focus on. And if you're able to merge those kind of two questions, right? The educational planning, what does your parents do? What do you want to do? What are your hobbies? What is something that's really interesting? Why do you want to study the US as opposed to other countries, as opposed to your home country? That's one thing. And then, well, how does this actually make America stronger, safer, and better? That's hard to say as an international student, right? But that's something that you kind of want to lead into. At least you're not a threat to the United States. At least you share your social media account so you can see, you're not anti-America, right, in any way. And the school, the population, and what you're studying totally makes sense with the U.S. economy.
So I just finished my interview on December 3rd, still waiting for my decision. Any thoughts? Is that normal?
If it's getting long, right? Because 6-7 months after an interview is definitely on the long side, but it completely depends on how long did you wait before the interview and what kind of interview and how strong or weak your case is. Generally speaking, a good case after the interview, approval within 3 months is most common. Some gets approved within a week.
This is for asylum interview.
Oh, asylum. Okay. That could take a lot longer. Yeah, so I was talking about marriage base and other things like that. But yeah, asylum cases could take a lot longer. But we don't do asylum, so it's hard for me to give you more specific numbers.
Where can I send you the paper that the officer gave us saying to wait and see? He said I should wait for mail to answer, or for answer.
Okay, so the paper probably is not that useful. It's just saying they're probably going to give you a request for evidence, so just wait. What's much more important is that you start preparing for the potential request for evidence, right? And if you don't know, just, do your best to improve everything in your case, right? Whatever you previously submitted, double, triple it, right? And you had the conversation with the officer, so you kind of know what they're looking for, maybe not, but just go ahead and prepare it. It's okay. What's much more important is once you get that notice, then book a consultation, and then we can dive in and we can, help you out. Like, I'll explain it to you exactly how I explain it to the interns, to the staff. This is how you should do with this case, how you should prepare it, and then you can do it on your own, right? You don't necessarily have to hire a law office to do it, but if you want to, if it's a really brutal and difficult one, sure, we could probably help, right?
A possible question doing AOS, son petitioning mom?
What are the possible questions? They are not going to really focus on the biological relationship, right? And so it's much more about public charge, good moral character, why'd you enter the U.S.? The May 21st memo might apply if she came in and just doing the tourist visa to adjustment status. We're starting to see requests for evidence come out. We haven't seen denials yet, but we are seeing requests for evidence. Is there something preventing you from adjusting a status back in your home country? What are you doing here? What's the benefit to the U.S., etc.?
Can I switch to a community college from a private university once I arrive to the U.S.?
Yes, you could do an I-20 change. That doesn't involve USCIS. Right now, you're still having duration of status, so it's a lot more convenient. In a few more months, it's probably going to go away, and then changing schools might become a lot more difficult. But as of now, you find a new school, you get a new I-20, the old school transfers to the new school.
Do I have a good shot at citizenship, or at least a residency, as an F1 student?
Well, F1 student, you become a green card holder first, and then from a green card holder, then you become a citizen. is there a good chance? Depends on your background, right? America wants certain type of people and doesn't want certain other types of people. They are very selective. And so going through the different green card options, take a look at what are they prioritizing. Ultimately, it's live your best life, become the most valuable person you can, and then see who wants to sponsor you, whether it's a job, whether it's a marriage, whether it's, investment, whether it's a startup. Improve yourself, improve your resume as much as you can. And if people really want you and there's really a lot of good opportunities, then there's a way. But it's not for everyone.
I have a marriage. Oh, is the K1 visa related to the travel ban? Have an interview, but my fiance has a Haitian passport.
I don't know. I think Gabby will know a lot more. She works with a lot more of 39 country bans, and she does a lot more K1 visas. So I think if you book the consultation with her, Spanish department. So if you go to our website, book the Spanish department, you can ask specifically about that, and she'll answer everything.
I have a marriage case, AOS, filed October 2025. Interview was in February. No decision, no work permit. What should I do?
Run the fact pattern again.
Yeah, marriage case, filed October 2025. Interview December of this year. Still waiting on a decision and a work permit.
Certain parts of the country definitely adjudicate these a lot faster. In California, because the interviews come so slowly, work permits and stuff come a lot faster. So, in your whatever state district you filed in, you probably got the interview within 6 months, and so the work permit is just slowly being delayed. There is another possibility is that they want to deny your case extremely fast. They don't even want to give you a work permit or travel authorization. So they scheduled it really fast and want to deny it really fast and cancel everything. That is a small possibility. I've seen USCIS do that. So it just depends, right? If you have a good case, hopefully your work permit is just going to come, and then your, green card's going to come later.
Can my wife, with a pending immigration case, can she come and visit me while under a seaman visa?
I have no idea.
She works on a cruise ship.
Okay. If she has a valid visa to enter the country, and she doesn't get turned away by customs, I don't see why she can't visit you, right? So if your question is, will her crewman visa, will CBP, will customs allow her in? I have seen a lot of customs officer deny people entry and say you have immigrant intent, and a crewman visa does not have dual intent privileges, so they could stop her. However, I also have used this argument with my clients to allow them in, even if there's an immigrant petition going. And the argument is, I am not going to immigrate this time. I'm coming in, I'm visiting, I'm leaving, here's my return flight, here's my schedule. There's no way I'm overstaying. I'm not going to give up this crazy good job and all this stuff, right? We are going to immigrate in the future, but it's far down the line. So you could try to use that argument and see if the officer believes you.
Okay, I want to get into the success story for today. Feel free to keep adding questions. I will take note of them, and we'll get to them after the success story.
This green card holder left the United States in 2019, and a series of unfortunate situations happened. Not just COVID in Asia, but the mother fell ill, almost lost her legs. The father had major diabetes and couldn't hear, couldn't walk, couldn't do a lot of these things. It was a very difficult situation that he had to stay back and care for. He was not in the best health condition, and he had to go through a lot of changes himself. Obviously, marriage and the kid outside of the country delayed his return. In any situation, you would think this person have abandoned their green card. They've left the U.S. from 2019 till now. It's 2026, right? 7+ years. 3 months ago, I think early February, March, we did a consultation. I reviewed everything. I said, it's a risky case. I'm not 100% sure you can enter. Let me see your documents. Let me see the things. And I'll do my best to try to talk to the officer for you. We spent 3 months to prepare. We collected all of their tax returns. We collected their property deeds in the United States and all the utility bills paying for their California residents. We collected all the medical documents from the father, the mother, and we prepared everything. And I went down to talk to the officer about this case. 9 years. I know it's a lot, but we've done other 9-year cases. We've done a 13-year case. What do you think of the situation? And the officer was looking at it and said, I don't even recognize this individual, right? The pictures don't line up. He left the U.S. 9 years ago. But the officer was very happy about the tax returns and the U.S. residency and all the medical conditions abroad. And so they said, are they going to be coming back here for good? And I said, yes, right? They are coming back. Their child is a U.S. citizen. The family here, they have a summer camp. They are going to come back. And they have all of these things. The officer said, okay, we'll arrange a date. Let's have them fly in. It's not a guaranteed approval, but based on my experience, talking to the officer, seeing the attitude, I felt pretty confident that this could work. I had the client prepare everything, fly in, gave him a lot of confidence, and it turns out he was actually staying at the same hotel as the Iran team for the World Cup, right? So he was staying in the hotel. Margaret and I couldn't get into the hotel. There was a bunch of cheers. We had to have him come outside, cross the street, then we picked him up, then we went to the border. We took his entire case, reviewed with the officer. And you know what? Most of the conversation, on top of everything else we talked about, most of the conversation ended up about how he lost weight. Because he lost over like 150 pounds or more. He lost a lot. He looks fabulous. To the point where we almost think, his sexual orientation might not be his actual sexual orientation. He looks that good, okay? The officer was a female officer, reviewed everything, and we were just having a great conversation. And we talked about the Iran team, we talked about Mexico, we talked about what he's going to be doing in the U.S., the school summer camp. We talked about a lot of these things. It was a quick conversation, but we prepared everything in case to prepare for the worst. But after reviewing everything, the officer said, looks good, looks legitimate, valid green card, welcome in. Now, after coming in, was stopped again at the other customs to check his luggage because, again, he had a lot of fitness equipment, opened everything, reviewed everything. Again, it was good. Then we came in, right? But long story short, the client left the U.S. for 9 years. Any other port of entry was almost guaranteed that his green card would be confiscated. He would have to go to deferred inspection. He would be inspected, ad infinitum, right? But we spent 3 months to collect everything. I went down, I was able to review with the officer, and we got the good sense that this case could be approved. And so we had the client come in, then we reviewed everything together, we came in, we talked to the officer, and it was a good conversation. We prepare for the worst, but we've done like 300 of these cases already, and so we kind of know what the officers are looking for. And again, the officers are looking for home ties, reasons abroad, and just your attitude, right? How you explain yourself, and the fact that we already had the summer camp stuff planned, the wife, the kids, all based in the U.S., husband coming in, the work, the tax returns, the job, the security, the finances. It's like this individual did not abandon the green card, even though the time was extremely long. We get it. It's over 180 days. It's over a year. The reentry permit expired. Everything we get it. But there were these reasons. Will you accept it? And he was seeking admission, but he was let in. And so I just want to share that story. Again, it's one of those things where even in this administration, even though the Supreme Court just landed that ruling that everybody is essentially seeking admission at the border, and they have a lot of latitude and discretion, but that cuts both ways, right? Everybody's seeking admission now. So who are they going to let in? Or are they going to just kick everybody out? They're still looking at the individual. They're still looking at you. Are you a plus for the United States or are you a minus, right? And so given the family background, given the property, given the arguments that we were able to prepare, the officer was okay with them coming in. And so just want to share that story. Shiloh did a great job preparing this case. The client is extremely happy, said this is like the best possible solution. And now he's very happy with his family going to summer camp.
Okay, that is our time for today. Thank you, everyone.
See you guys next week. Take care. Bye-bye.